Tejas Satisha Hinder, Senior Editor at the Contemporary Law Forum, would like to take this opportunity to welcome all our viewers and Professor Hayleigh Bosher to another episode of the TCLF One-On-One. At TCLF One-On-One, we have always aimed to host legal luminaries from all across the globe in an attempt to initiate nuanced discourse on contemporary issues and developments in the field of law. In an attempt to initiate and further discourse on such a nuanced and intricate field of law, we have with us today Dr. Hayleigh Bosher. I apologize, Professor Dr. Hayleigh Bosher. Before we proceed, I'd like to give a quick introduction to ma'am's nature of work and how ma'am has contributed significantly towards the field of intellectual property law. So Professor is a senior lecturer in intellectual property law at Brunel University London. In addition to this, she is also a visiting research fellow at the Center for Intellectual Property, Policy and Management. And she's also a writer and book review editor for the specialist IP blog, the IPKat, and also the founder of the World IP Women Network, which is a notable intellectual property organization. And finally, ma'am is also an intellectual property and entertainment law consultant. Professor's main research areas include copyright enforcement and infringement in the entertainment industries, particularly in music, social media, online, and more recently in artificial intelligence. It is our pleasure to have you with us today, ma'am. And we'd also like to take this opportunity to congratulate you on your recent publication, which is the book on copyright in the music industry. And I'm sure it has contributed immensely to the existing literature that exists on this nuanced and niche area. Ma'am, we as a student community in the legal field do have one pressing question that always comes up to our mind whenever this book is brought to light. What inspired you to take up this project, and what are some of the important themes that you have attempted to cover in this book?
Well, thank you very much for that delightful introduction. I feel great about myself now. That's nice. So here's my book. Yes, I'm very, very happy to finally see it in real life because I wrote it during the first lockdown of the pandemic, although, of course, the idea for the book came before that time. In terms of what inspired me to write the book, it was kind of a combination of things that my research had sort of moved into that area, and I just find it so interesting for myself. And I love music, and I love talking to artists and musicians about their work. And I found that a lot of the people that I spoke to were very unsure about their rights. And so the whole point in the book is to help people in the music industry understand more about what copyright is and how it works for them, because it's a real area of misconception, and it brings me a lot of joy to demystify something that appears to be confusing and difficult and even boring, and try to make it fun and interesting and relevant for those people. So that was really the key sort of motivation behind the book.
Thank you for that, ma'am. I think that's really insightful, and that's really motivating for a lot of us who are like attempting to do something of this sort. Ma'am, what are the if you could name a few, or if you could kindly indicate as to what exactly you've attempted to cover in terms of the themes that this book addresses?
Sure. So the book is called Copyright in the Music Industry, a practical guide to exploiting and enforcing your rights. So as I said, the main objective, first of all, is just to try and engage people who are in the music industry, maybe songwriters, musicians, artists, but also managers and producers, into the conversation about copyright, because copyright is a conversation. Copyright is always changing and evolving. So it's not like you can read this one book and the journey is done. It's like you read this book and the journey has begun. So what I try to do is introduce copyright, cover some of the basics, and explain what it is, how it applies to music. And then I cover some of the kind of topical issues in music about copyright infringement, for example, like when does one song copy another song? which you, I'm sure, know is a nuanced issue. It's not that straightforward, but it's in an interesting and fun way. I also tried to explain a little bit about how licensing works, how artists and musicians can get paid for their music. And it kind of takes the reader through the journey of owning and enforcing their rights should they have to go that way. So, for example, if they feel that their copyright has been infringed, what do you do about it? What court do you go to? When do you hire a lawyer? Should you settle? Should you negotiate? All that kind of stuff, like trying to help people understand a little bit about what that journey would look like in terms of enforcement. And then, for example, if you did win a case, what happens, like in terms of remedies. So I cover like damages and injunctions. And as I said, I also touch on some topical issues like social media, and the two final chapters cover artificial intelligence and blockchain, which are just kind of, as I said, engaging the conversation of like some topical issues around copyright that may affect the rights of people in the music industry, encouraging them to get involved in these conversations.
Absolutely, ma'am. I mean, it's a real motivation for us. Like, whenever we're passionate about something and we've studied something else, so just to find that intersection and kind of develop what we've studied into, so that the issues in whatever we're passionate about get covered, is something that we can really stick to, considering the example that we've seen across coming from your end, and it's really motivating, ma'am. And congratulations once again. Ma'am, another question that a lot of us do have, considering you specialize in this area, is that, of late, there's been a lot of debate regarding the rights of artists versus the rights of labels, and especially regarding the issue of copyright ownership and royalties, which do arise in due course once this conflict does come into play. So what are the reasons behind this continuous tussle? And, is there a means by which this could be resolved?
I think that's a good question. And yeah, if you've been engaging in the conversations around copyright and music, you'll know that there's kind of, I don't know that I would call it a tussle, but there's definitely some movement there. And I think it's important, again, like what I was saying about the book is, you have to be able to understand some copyright basics in order to be able to get into this conversation, because the rights in a song are or can be divided or owned by different people. And so if we didn't know anything about copyright, you might assume that the copyright holder is the person who wrote the song or the person who sings the song. When in actual fact, if they're signed to a record label, often it's the record label that own the copyright in the sound recording of the song. And if they're signed with a publisher, then perhaps the publisher will own the copyright in the actual song composition. And then the performer will have a right in the performance of the song. There's different people and there's different dynamics, and it can be, it can appear complex at first, but I think you can get your head around it. In terms of the conflicts that's going on at the minute, so it's not really a case of the right of the label or the right of the individual artist, because it's about how the artist is remunerated from that right. So people have different views on how much rights should be given to the record label in order for them to fulfill their role in the dissemination of music. But that's not really, I don't think, what the conversation is about at the minute. At the minute, the conversation is about the fair share of the revenue, because the three major record labels are turning over an enormous amount of money, and they're very, very successful in their dissemination of music. But what's happening is there's lots of artists who are struggling to make a fair, reasonable income, even though their work is streaming online. This has come about, I think it was an issue already, but the pandemic has definitely put focus on this issue because other forms of income were stopped. So we couldn't perform anymore, and therefore you don't make a performance income. Bars and clubs and restaurants are closed, so you're not making money from the royalty payments for bars and clubs and restaurants. So then artists are relying on the income from streaming and music consumption, which actually rose during the pandemic, but it highlighted to them and gave them time to reflect on whether they think that this share of the music revenue is actually fair or not. And this is something that is currently being reviewed by the UK government in the streaming inquiry now.
Absolutely, ma'am. Thank you so much. That was really insightful. But like that just gets me another, that just brings another question to my head, because you spoke about dissemination, right? Dissemination of this particular music and how the rights subsequently do arise. Ma'am, I think recently we've observed the rising of platforms like Spotify and Apple Music, which have become increasingly popular with users as well as musicians. And just so that we're like on the same page, it's Spotify convinced a handful of artists to use the marquee feature, which sends notifications to listeners whenever the artists release new songs or albums. And this sort of participation includes notable artists like Justin Bieber and Lil Wayne. Uh, so, I mean, what kind of copyright issues possibly arise in arrangements like these?
I'm not really sure. What do you mean about the copyright issue? Sorry.
Yeah, ma'am. So basically, in the process of dissemination, when there are notable platforms like these, wherein the work of musicians are being put out on an initial basis and a notification is sent out to users whenever a particular song is released, subsequently, it may happen that the musician goes ahead and releases this music alongside another label. And at the same time, there is a possibility that before, once it's notified through these features, it's always possible that another user or another artist who's in fact using this gets hold of this particular music and goes ahead and disseminates it through another label before the original creator goes ahead and does that. So copyright issues do arise, I believe, in this transit. So is there anything that like we'd have to specifically know in terms of how this is working out contemporarily? Because I think from the student fraternity point of view, this is just the basic and vague idea that plays out in our mind.
Well, I think it's important to remember that copyright arises automatically. So if the song is pushed out on a platform and then it's copied by somebody else, this would be a copyright infringement. It doesn't matter if the person is signed to a label or not. They still have copyright in their work. And in fact, they have more rights if they're not signed to the label because they haven't handed over any of their rights to the label. If they are signed to a label and you infringe the copyright, you'll be infringing the copyright of the label rather than the individual artist. So infringement of copyright is an interesting area because it's not just about, you can hear a song and take inspiration from that song and make another song using your own creative choices, your own personal stamp, all of those things. It's okay to be inspired by other music. In fact, it's more than okay. It's how music is made. It's how we learn to play an instrument. We learn to play other people's songs. What you can't do is take a substantial part of another person's song, which is the original parts of their song, and copy that without it being copyright infringement.
Absolutely, ma'am. I completely understand that. But, there's this question that's backing my head again with regard to how this particularly occurs, right? So see if there's a, music platform that's there through which artists put out their work. And, there is like assuming XYZ exists, XYZ music streaming app exists, and they have a condition that once an artist puts out their work through this particular app or streaming service, then the streaming service will exercise, complete right over this work, and this work will continue to exist. So the creator cannot, go ahead and put out the work through another label or another music streaming app. So in instances like this, is this activity sort of discriminatory, or is it like justified in business interests? Like what takes a primacy here?
Well, this would be governed by the terms and conditions of the service, right? So I would advise people to certainly read those and understand the impact of those and make informed decisions. I don't think really for us to say whether we think that people can do whatever they want with their music. What I'm concerned with is people making informed decisions and knowing the impact of that. And I think if they really understood the value of their copyright, they wouldn't give it away so easily to simply an app takes control of the ownership of the work, which is, I think, what you're insinuating. So I think that it's a business model. I don't necessarily have a view on whether I think that's I tend to lean towards the artist side, that I think that that's probably like not Well, like I said, if they know that's what they're agreeing to and they want to agree to it, that's their freedom to do so. And maybe, like you said, some artists would benefit from it in terms of, I don't know, getting a bigger reach from their audience or something like that. But I would say to read carefully the terms and conditions and decide if you want to give your copyright away, because it might then hinder you further down the line. Like you said, where you aren't able to sign. If you sign a record deal, you can't sign a record deal with a song that you already gave to somebody else. So you just wouldn't be able to do that. So that would restrict you from doing that with that song. But there are artists work in different ways. I know of lots of different models where people, for example, songs on a salary and they get no rights in their work. They just simply get paid a monthly salary and that's what they do. And, you know, it's up to that person whether they decide that that's what works for them. As I said, I'm more concerned with people understanding the real value of copyright, and maybe they would get much more from their work if they did retain the rights and they received their appropriate royalties.
Absolutely, ma'am, absolutely. And I think it's a good takeaway for some platforms that exist, for example, TikTok. And I think that that's a great insight that you've really given us. One final question that I had, I think, which is again boggling the mind of law students who are inclined towards this line. So it's just that, you know, earlier copyright laws used to protect only the lyrics and melodies that were in a song, right? Earlier. But you know, the blurred lines lawsuit that happened suggested that, you know, the far more abstract qualities of, say, rhythm, tempo, and even the general feel of a song are also eligible for protection. So it gets really like intricate and nuanced. And so a song can be sued for feeling like an earlier one. Uh, and then, you know, this was also the case with, like, just to take an example, Katy Perry's Dark Horse song, which had allegedly copied the beat from the little known song of the name Flame, was came across as a shock to both the music business and the legal community. And the lawyer who was particularly arguing in Katy Perry's defense famously said that they're trying to, you know, own basic building blocks of music and the alphabet of music that should be available to everyone. So, because it's getting really technical and really intricate, whatever could have initially led to the formation of that very song or that art is something that's becoming eligible for protection. So, there's no incentive, not or more than an incentive, there's no basis that is created for artists who do want to develop using this very intricate foundation. So, you know, to what extent do you think, to what extent, because like we don't have a definitive threshold in the status quo, so what extent do you think this kind of copyright protection should be and can be given in the music industry?
That's a good question. I just wanted to say about the TikTok thing first, because you said TikTok.
Yeah.
First of all, TikTok is actually licensed. So the music that is on TikTok library is licensed and royalty is paid to the music artist. What they ask for you to surrender all your rights when you do the piece is partly because of the function of TikTok being that they want people to repeat the sound within the app. And so that's kind of like the function that they're going for, whether we agree that that's appropriate or not. And even though it's great to hear that they've started to be a licensed platform, all of the agreements between TikTok and the labels and everything is secret. So we don't know what the deal is, how much money, whether it's a fair deal or not. But that is there. In relation to your question about the scope of copyright, that's what the question is about, isn't it? Like, how much should it protect the feel of a song? First of all, we need to acknowledge that copyright is territorial. So these are US cases that we're talking about, which means they would only apply in the US and not, for, say, for example, in the UK or anywhere else. But also that since we had the Blurred Lines case and we had the Katy Perry case, the song was called Joyful Noise. It's the artist that's called Flame, but don't worry. But then we've had the Led Zeppelin case, okay? So it's my view that the Blurred Lines case was too broad in protection of copyright, but it also comes down to a case-by-case basis. And the facts of that case included that the artists of the Blurred Lines song admitted to trying deliberately to recreate the sound of Marvin Gaye. And I think that was very detrimental to their case. But I also have a lot of issues with that case, how it was decided, the musicology reports, all that stuff. Katy Perry, so she originally lost the case for this 8-note ostinato that was claimed that she copied in her song Dark Horse from another song called Joyful Noise. Then we had the Led Zeppelin retrial, where the US courts clarified that there are key elements in music in particular which need to be freely available in the public domain for everybody to use in order that music can be continued to be created all the time. And they specifically said chord progressions is one of those factors. So then after the Led Zeppelin case, the Katy Perry case was appealed and she was found not to be infringing because there was no copyright protection in the 8-note ostinato in the first place. It was something that's general in the public domain. So I believe that process, the scope was broadened by the Blurred Lines case and has been kind of rebalanced a little bit by the Led Zeppelin case. And I think if we had the Blurred Lines case now, it would have a different outcome potentially, or perhaps a different, at least a different judgment in terms of reasoning, how they came to that decision. I think it's very important that the scope of copyright is appropriately balanced so that there is always room for creativity. The whole point in copyright is to promote creativity, not to be a barrier to creativity. So we should protect the individual expression and the original elements of a song, but we should not be protecting things like a chord progression that is often used in music. And the reason why music is such an interesting case in this sense for copyright, because the same test applies for if you're copying a drawing or a photograph or other, literary work, other works that copyright protects. But the thing about music is there is such a limited, amount of notes that you can use. And also we work within genres, tend to work within genres in music. So that means that you have even less of a choice available to you because the listeners want to hear something that tells them this is pop music, this is jazz music, this is blues music, this is R&B music. So it has to have those key elements already of that genre in order to connect with that audience straight away, which means your choices are automatically, you're limited by straight away. So in the public domain. I think what's interesting is when someone comes up with a new thing that creates a new genre and then becomes a signal for that genre. And then you can really argue, well, it was new, but now it becomes an element of that genre. So anybody who wants to create a song within that genre, do they have to pay a license for that beat, if it's a beat? Or should it be, it's now kind of plateaued and it's become something that's in the public domain? That's the interesting question, I think.
Absolutely, ma'am, absolutely. And just because you spoke about the subjectivity that would exist in issues like this because of the varying laws in separate jurisdiction, like you notably mentioned that an issue that could have possibly translated into one in a particular manner in the United States could not have happened the same way in the United Kingdom. Ma'am, in this era that's existing, we have the play. Is it but fair, to bring out some sort of, international legislation, like not a separate one possibly, but at least a provision under an existing international legislation, so as to ensure that this sort of discrepancy is prevented because of subjectivity due to varying jurisdictions?
That's an interesting question. I think it makes sense that because of the internet and the globalization of the world and the globalization of music, you could have a strong argument for an international minimum standards for infringement test. I think, for example, when I say that there could be a difference, and there often is, like sometimes in my classes, I'm comparing different cases for my students to say like, oh, this would be an exception in, fair use under US law, but it wouldn't apply to fair dealing in the UK. And that seems unfair to me in the sense that you can make something wherever and then produce it in one country, but you can't produce it in another country. But at the same time, that infringement in the US is actually quite similar I would say, broadly speaking, to the one in the UK. It does come down to a substantial part. What's different is the real specifics of the factors that take into consideration for whether there's been an infringement or not. But yeah, I don't know. I don't know. I'm not really like, I don't have a strong feeling towards harmonization of copyright, because I do think that it's so closely connected to culture, and sometimes I think there's a benefit to the freedom of each jurisdiction being able to decide its own kind of nuances. And like, we have such a huge body of jurisprudence in this country. That's what I'm thinking of. And then I'm like, and then whose test would we choose? Like the US test or the UK test, or the test in India or Sri Lanka, or, you know, these so many different ones. Like, which one would you choose, you know?
Absolutely, ma'am. Thank you so much. Quite an insightful insight. And I think that brings me to the end of the concerns that we as student communities had, especially to put forward to you, since this is your so much for patiently going over each of these and explaining everything so intricately. And it was really a great opportunity, and it was I think a heartwarming experience to have hosted you. And many congratulations on your literary work once again. I really hope that book is available online, because I'm personally reaching out to that and really looking forward to reading it. Thank you so much for tuning in, ma'am. And if there anything that you'd want to leave as a final message to all the people who'd be viewing this episode of the TCLF One-on-One?
Well, just thank you so much for having me. I love talking about copyright all day long, so I was absolutely happy to do so. The book is available as an ebook and an audiobook, so you can get it any way you like.
Surely, ma'am. I'm really looking forward to it. Thank you so much.